Good morning and good afternoon, everyone. Thanks for being with us today, and welcome to our latest ITInsights virtual briefing. Today's edition will focus on the European Commission's new draft adequacy decision that was released earlier this week as part of the EU-US data privacy framework. Last month, ITI led a broad transatlantic coalition of 41 associations representing companies of all sizes and representing all sectors of the business community, urging EU policymakers to release this decision. We now are encouraging EU member states to work with the various EU institutions to adopt the draft adequacy decision and ensure successful implementation of the EU-US data privacy framework. Today, two of the industry's foremost policy experts, ITI's Guido Lobrano and ITI's John Miller, will be with you to analyze this decision and describe how these actions will help restore business certainty and create continuity of key operations, while also upholding European citizens' fundamental rights and the security and public safety interests of the EU, US, and other countries. We encourage you to join today's conversation by adding your questions in the chat. Guido and John will be happy to answer them later in the hour. And now let me turn it over to Guido Lobrano. Guido is ITI's Senior Vice President of Policy and our Director General for Europe. He leads ITI's EU team, which is based in Brussels. Guido, I'll turn it over to you.
Thank you, Ashley, and good afternoon or good morning to everyone. Very happy to be joined here today by my colleague John Miller to discuss about the recently released draft adequacy decision by the European Commission. As Ashley mentioned, the purpose of today's call is really to provide an overview of the draft adequacy decision and also put it into a broader context. Also so that you don't have to read it all. It's a 60 pages document that goes through a number of very specific criteria to assess the US legal system as regards the protection of personal data of European citizens, but also more broadly. And so we will look into that. We will look at what are the implications of the draft adequacy decision. We'll start with what is an adequacy decision as well, and then we'll look into the more details as well as some additional I think elements that are important for the broader context. Let me start by maybe briefly addressing what an adequacy decision is. As many of you will know, an adequacy decision is a mechanism that is provided by the General Data Protection Regulation to allow the transfer of data from the European Union to third countries based on an assessment made by the Commission that the third country provides an adequate level of protection that is essentially equivalent to that of the European Union. And this is the result of both existing legislation as well as a number of rulings by the European Court of Justice. So when an adequacy decision is in place, data transfers to the third country can be processed in the same way as intra-EU data flows. The European Union already has adequacy decisions in place for a number of other countries, including Japan and the United Kingdom, which were the last ones that have been adopted. Now, under the EU-US data privacy framework, companies will be able to certify their participation in the scheme by committing to comply with a number of very detailed privacy obligations that are outlined that are outlined in the executive order. I also wanted to mention that recently, there has been a lot of talks in Brussels and in Europe about this. Apologies. The Parliament has also published a report that outlines the first reactions to the executive order and refers to the views of public entities and DPAs. I'm sorry for my voice. Let me turn to John Miller, ITI's General Counsel, for an overview of the key elements of the draft adequacy decision that has been published by the Commission on Tuesday. John, I'll turn to you since my voice is failing me, and I'll drink some water.
Thanks, Guido, and yeah, definitely get some water. And hello, everybody. Yeah, so I mean, we will certainly get into all of this in a little bit more detail. But the the key elements, as Guido was beginning to articulate, are the follows. I mean, as follows. I mean, I think most importantly, and at the top line, what the commission is doing here is declaring that the U.S. system provides an adequate level of data protection, and specifically, the commission does a couple of things, right? They say they've carefully analyzed U.S. law and practice, including the new executive order 14086 and the AG regulation. And, then they go into a quite lengthy list of, 190 some odd recitals, to conclude that the U.S. indeed does ensure an adequate level of protection for personal data transferred under the data privacy framework from a controller or a processor in the EU to certified organizations in the United States. It has the effect that personal data transfers from controllers and processors in the EU to certified organizations in the US may take place without the need for further authorization. And then significantly, the commission considers that the US, again, through these principles, which we'll get to in a moment, issued by the Department of Commerce, ensures a level of protection for personal data transfers that is indeed essentially equivalent to the protections guaranteed by guaranteed in the GDPR. It does not. There are no additional changes required to the U.S. system, particularly in light of the new executive order and Department of Justice regulations. With the caveat that there is still some implementation activity that is happening, which will also, and that needs to happen, which we'll get to also in a little bit. Significantly, they do go into quite a bit of detail on what is now called the data privacy framework principles that have been established by the Department of Commerce and replace the prior Privacy Shield principles. Again, I guess the one other thing just to note is that, as I mentioned previously, this is a certification program, the data privacy framework principles. And so when the adequacy decision, assuming it is final in 5 or 6 months' time, one of the things that's important to note is that transfers will be valid for those companies that have certified to the Privacy Shield program. So I'll pause there and we'll see if Guido has his voice back.
Yes, thank you, John. I hope I'm okay now. Brussels is very cold this week, so I guess I was hit by that. Apologies for that. So thanks, John, for this initial overview. I know that there's another couple of recent developments that we may want to touch upon during this call. Maybe we can briefly mention them now, and I'm referring specifically to the recent intelligence community directive that was published yesterday, I believe, as well as the OECD declaration on government access to personal data. We can come back to those, but can you just very briefly say a couple of words about them?
Yeah, sure. I mean, I'm glad you flagged both of those. As I just mentioned, even though there are no further changes to law that will be happening or required to fully implement the executive order in the Department of Justice regulations, there are still some implementation details that need to happen. I mean, one of those key milestones was yesterday, where we did see this intelligence community directive, which is providing some implementation procedures, in particular for some of the signals intelligence redress mechanisms under the EO. And then also very significantly, and I do hope we have a little time to talk about this. I mean, the OECD just yesterday published a declaration on government access to personal data held by the private sector that happened at the OECD Digital Ministerial in Spain. You know, it's a significant milestone just because it talks about some of these very same issues and discusses the commonalities on a multilateral basis as opposed to just bilaterally between the US and the EU. So, you know, thanks for referencing both of those.
Thank you, John. And indeed, the OECD declaration was adopted by in Gran Canaria by the governments of the European Union and United States, as well as other relevant countries like the UK, and also individual member states of the EU, among others.
Yeah, 38 members in all, I think, right? So,
exactly.
Anyway.
So if we go back to the our overview of the draft adequacy decision, I think what's very interesting is if you look at the second section, section 2, essentially what the Commission does in this part of the decision is look at the data privacy principles and score them against key protections that are outlined in the GDPR. Is there something that we should be highlighting on the key principles here?
Yeah, I mean, so first of all, I mean, for those who are familiar with the privacy shield principles, I mean, I think at the top line, the principles themselves, I don't believe have changed here. And I mean, just to kind of quickly run through what those principles are, they embody a lot of things you might expect that are also enshrined in the GDPR. I mean, things like notice, choice, accountability for onward transfers, security, data integrity and purpose limitation, access, and then recourse, enforcement, and liability. Again, it is important because the data privacy framework itself is based on a system of certification. So these U.S. organizations are committing to uphold all of these privacy principles, which are, as the Commission details, are aligned with various protections of the GDPR. And I think that is the one thing in particular that I'd like to highlight. I mean, as hard for it is to believe, when we had the first Privacy Shield agreement back in 2016, the GDPR was not even yet in force. So the initial set of Privacy Shield principles, even though they covered the same area, those principles referred to the predecessor, data protection directive, as opposed to the GDPR. So now all of the references, at the least, have been updated to reflect the GDPR coming into force in 2018. And so I think that's probably the biggest difference, although I wouldn't call that a major substantive difference. But it is important and an important reminder that companies certifying to those principles are certifying to a set of principles that aligns with the same protections under the GDPR. On the commercial side.
Yeah. Before we continue with this overview, I just wanted to highlight that, of course, all the participants online here are very welcome to ask any questions through the Q&A function. We'll definitely be happy to try and address them later on in the call once we have finished this overview. So please don't hesitate to click on the button at the bottom of your screen and write down your question. So, John, the core of the adequacy decision is essentially the Commission's determination of how the U.S. system protects personal data of European Union citizens. There is a specific part in the decision, which is recital 87 in the section 3, which provides the criteria under which the Commission runs the so-called essential equivalent test. And this is specific referencing how U.S. authorities access personal data for various purposes. So which has always been one of the core issues of the whole transatlantic data flow dynamic. Can you maybe tell us a bit more about how is the Commission is doing this, how it's looking at the principles of legality, necessity, and proportionality, and how these are reflected in the U.S. system?
Yeah, sure. Happy to. Yeah, as you point out, and maybe just to kind of briefly go back to, I think, something we covered in the last the last time we got together and talked about the issuance of the executive order itself. I guess a couple of months ago at this point. The executive order was reflects kind of the driving organizational principle that I think animated the entire negotiation, which was to address the deficiencies that were identified by the Court of Justice in the Schrems II decision, with the U.S. system at that time, and those specifically referred to, the two broad categories were the necessity and proportionality, of course, as you mentioned, and then redress, which I know we'll get to in a bit. I mean, to put it simply here, I mean, I think, the executive order is really the key document and reflects the key changes in U.S. law to, in the Commission's view for sure, and I'm sure in the U.S.'s view as well, that set forth appropriate limitations and safeguards for all of the U.S. signals intelligence activities. So that's applying to the collection of data both inside and outside the U.S. In particular, the executive order from October and the regulation, I think probably you could say there are three kind of categories of protections, right? I mean, there are, there's binding safeguards that limit access to data by U.S. intelligence authorities to what is necessary and proportionate. In order to satisfy the requirement of proportionality, according to which the derogations from and limitations to the protection of personal data must apply only insofar as is strictly necessary, in a democratic society to meet specific objectives of general interest equivalent to those recognized in the EU. I'm quoting from the adequacy decision there, but the point is that the legal basis has to lay down clear and precise rules governing the scope and application of the measures in question, and also impose minimum safeguards so that the persons whose data has been transferred have sufficient guarantees to protect effectively their personal data against the risk of abuse. I mean, I guess just on the necessity part again to underscore it, any limitation on the right to the protection of personal data must be provided for by law, and the legal basis there is set forth, pretty specifically in the executive order itself. I will say, some of the criticism, there are criticisms that, just saying that this is necessity and proportionality, using those terms, that in itself is not enough. But if you read through the executive order, and obviously the Commission goes into quite a bit of detail here, it defines and provides for various different factors and criteria that the intelligence community, must consider. For instance, to what extent and to which it should collect data. What are the techniques? making sure that these are connected to the seriousness of the threats, the likely impact on individuals. I mean, they're also going into what cannot, qualify as a valid, a necessary and proportionate purpose for that sort of signals intelligence collection.
You touched upon redress, which was one of the sticking points from the previous, from the Schernster ruling regarding the former privacy shield. If we look at what we have here, I think there's a lot more than it used to be. There's different possibilities for individuals to bring complaints, both in the United States, but also directly through European Union entities and the European Union data privacy authority. So can we look into some of these elements a bit?
On the redress side, yes, yeah. I mean, absolutely. I mean, the most, well, first of all, I mean, it is fair to I guess maybe remind everyone that there are a number of different redress avenues that the commission details. And again, redress is one of the principles itself as well. But it's just it's perhaps useful to go through all of them and then talk about in particular a little bit more deeply what the redress, the newest features of the redress solution are that are highlighted here and that were provided for by the executive order and Department of Justice regulations, right? But there are at least 7 different avenues of redress that the commission details in the adequacy decision. Number one, EU citizens can pursue cases of alleged non-compliance with the principles, through their direct contacts with EU, US certified data privacy organizations. They can bring complaints directly to independent dispute resolution bodies in either the US or in the EU that have been designated by the organizations to resolve these types of complaints. Individuals can bring their complaints directly to a national DPA in the EU. Let's see. Fourth, the Department of Commerce also. The Department of Commerce, just as a reminder, it does administer this the data, what is now called the Data Privacy Framework and Data Privacy Framework Principles Program itself, and they are also committed to receive, review, and undertake best efforts to resolve complaints about alleged non-compliance with the principles. Fifth, an organization, and this gets a little bit more into enforcement, but they're subject to the jurisdiction of U.S. authorities, in particular the FTC, which can investigate the complaints, any complaints that have been alleged. Sixth, and what was previously called, considered the kind of the mechanism of last resort was binding arbitration by the EU, regarding alleged non-compliance with the DPF. But then significantly here, seventh, the commission goes through a variety of other additional avenues for judicial redress that are available under U.S. law, including for instance violations of state consumer protection laws, and other and other things, and then when we of course get to the new redress solution itself, there is the 2-layer redress system that has been established here, an establishment of an independent and impartial, data protection review court in particular to investigate and resolve complaints regarding access to data by U.S. national security authorities. That is very significant on the redress front, and happy to go into a little more detail about that, but I'm conscious of the time.
Yeah, absolutely. I mean, as we talk about redress, we mentioned in the beginning of our call that there has been, I think a couple of days ago, the adoption of this new intelligence community directive that implements procedures for the redress mechanism related to signals intelligence activities. For us Europeans who are less familiar with the US system, can you tell us a bit more about what an intelligence community directive is and what specifically this one does?
Oh, this is, one of the things that, is required because we have a new court here that's been established. So there are just a number of different, just implementation details that need to be worked out, even things like the naming of judges, really ironing out the different types of procedures and how it's going to function. Here, and again, but my apologies that this has just been published yesterday. But it's just, I think what's most significant to me about it is, I think one of the things that's been noted, and the commission's adequacy decision itself even notes that it says that the finding of adequacy is conditional upon all of the details of both the executive order and the DOJ regulations being fully implemented before the adequacy decisions in place. And so one of the things that I think we've all been waiting for since the agreement itself, or since the executive order and the DOJ regs were published, was to see what some of that implementation activity, and we have one major tranche of that implementation coming forward, just yesterday. To be fair, there are other implementation details that do still need to work out, or to be worked out, and we can certainly get into those as well if you'd like.
As you pointed out, the entry into force of the decision, the Commission is very clear, is conditional to the US government adopting these policies and procedures that are needed to implement the executive order, and this is one of those. And we'll go into the adoption process for the adequacy decision that will roughly take 6 months. But maybe on the US side, what would you say? Would you expect this process to be completed by the time that the adequacy decision needs to be finalized? Is there a lot to be done? Who is going to be in charge of these implementing acts?
Yeah, that's certainly a good question. There are a number of different timelines, and actually the adequacy decision does go into them a little bit here. Let me see. There is I'm sorry, let me just find this exact okay. The timeline for the EO becoming fully effective, number one, it must be implemented into day-to-day operational policies and procedures throughout the entire intelligence community, within 1 year of the publication of the executive order. So, I mean, that would be by October 7th, 2023. But that's kind of an outside date. And then further, it says the procedures must be, of the intelligence community agencies themselves must be developed in consultation with the Attorney General, the Privacy and Civil Liberties Oversight Board, and the Civil Liberties Officer of the Director of National Intelligence. And they also must be made publicly available. And then once finalized, the PCLOB, again, Privacy and Civil Liberties Oversight Board, is then going to review those and issue recommendations. And that's kind of part of more of the oversight here, but that has to be taken into account within 180 days. But going back to that 1 year publication date by October 7th, 2023, I would I would anticipate that's going to happen certainly more quickly than that, particularly in light of what the commission is saying. I mean, it's clear that they're already working on this in the intelligence community. I don't have inside knowledge of that, but just the fact that I think they wanted to get the court up and running, and having some of those procedures in place, I would anticipate was really important. But and that's obviously on the redress side. But in terms of the necessity and proportionality piece of this, and really making sure that all those safeguards in place, I am presuming that the wheels are all in motion for that, and hopefully that will be done certainly well prior to next October.
Thank you. And I remember, the timing was a bit of an issue at the time of the Privacy Shield, where some of these positions, including the ombudsperson, remained unfilled for a while, which was a bit of a concern for the whole framework. There's clearly a lot of authorities on the US side that are involved in this, especially when you look at the enforcement. You see the Federal Trade Commission, Department of Commerce, and also Department of Transportation. Can you maybe just at a very high level talk about the role that these different authorities will play in the enforcement?
Yeah, sure. And talked about this a little bit already with respect to the Department of Commerce, but number one, I mean, to reiterate, the data privacy framework is based on this system of certification. So the Department of Commerce's role there is both as the administrator of this certification program. But as I highlighted earlier, the Department of Commerce itself is also equipped to handle complaints regarding a particular certification. It's really in terms of the actual enforcers of the principles. The draft adequacy decision makes clear that it's the FTC, the Federal Trade Commission, and the Department of Transportation, which both have, and it goes into quite a bit of detail, the necessary investigatory and enforcement powers that are required to effectively ensure, compliance. And they even talk about the FTC, having the prior record of enforcement under Privacy Shield, which was something like 22 cases of Privacy Shield enforcement. The Department of Transportation, for those who are wondering, is kind of a necessary enforcement player, particularly in the context of, for instance, airlines who they have jurisdiction over. So to the extent you have airlines that are certified to the framework, that's where the DOT comes into place. But they have very similar authorities, enforcement authorities in that regard.
Thank you for that. I think when we look at the overall approach of the Commission in this draft adequacy decision. It also shows how the Commission is addressing some of the early criticism of the executive order, namely, from those saying that there is actually no guarantee of effective implementation. But in fact, one of the conclusions of the draft adequacy decision is that the effective application of these principles is guaranteed here by the transparency obligations and the fact that there are concrete ways to identify and punish breaches in practice, and also that there are now effectively remedies that are offered by the US system. So, I mean, overall, this is also, in a nutshell, the assessment that ITI and a number of other business groups have shared in the joint statement that we have done a few weeks ago. So maybe I'm looking at at our chat to see if there are additional questions, and while I wait for any other questions to come up, I will maybe briefly summarize what is going to happen now on the EU side with the prosecution of the adoption process of the adequacy decision that has been published this week. So this is a so-called implementing act that has to be adopted formally by the member states of the EU in a comitology procedure. It is a process that is expected to take roughly 6 months. This has also has been stated recently by Commissioner Reinders. In the meantime, through the discussion with member states, there will also be an opinion that will be issued by the European Data Protection Board that collects the voices of the DPAs. Sorry. John, I'll let you continue.
And I'm sorry, so you just got to the point where the EDPB is going to provide an advisory opinion. Yeah. So yes. Sorry. So there are, and I think if you go to the agreement itself, I mean, I think there's even placeholders in place here for the for both. There are three things that really need to happen, right? You've got the opinion of the European Data Protection Board, and again, this is not while it's not a binding opinion, it is nonetheless very important. And I believe that in the past, for instance, when the Commission has been has issued a draft adequacy decision, not just in the US context, but in other contexts, they certainly take under advisement the European Data Protection Board's opinion and are able to make adjustments to the adequacy decision as required. In particular, and that's why this is a draft adequacy decision and not a final adequacy decision. You've also then got the European Parliament, who will take a look at the draft adequacy decision and likely issue some form of resolution. And then, of course, you've got the European Council, ultimately being in a position to ratify the decision. So, Guido, I see you're back, and
yes,
hopefully I covered the three main things.
Thank you.
Maybe something.
No, that was great. These were the points I planned to make. Sorry for my voice keeps on leaving me. I think one additional specification, as you were suggesting, the opinions are opinions, but of course the Commission needs to address them and could adjust some elements of the adequacy decision. It has happened in the past. There could be additional requirements put on the US administration in this case to implement additional measures when that is felt necessary. While I see if there's other questions, I don't see more questions now. One of the other points I'd like to highlight at this point is that ITI will also be hosting an event with EU Justice Commissioner Didier Reinders on January 25th in Brussels, where we will have the opportunity to hear from him and already make a first preliminary assessment of how the adoption process is taking place. We will soon send public invitations to attend the event. We hope you can join us and see where the discussions stand. Of course, member states will play a key role in this, and we will also be discussing with national administrations to see how their deliberations are moving forward. Also wanted to point out that we have shared in the chat to this discussion a number of links to several documents that we have referred to in our conversation. Not only the actual draft adequacy decision, but also the reactions to the executive order that has been compiled by the European Parliament Research Service, the declaration of the OECD, and the Intelligence Directive. Maybe, John, we can spend a moment talking about the OECD declaration and the implications this has, more broadly than just EU-US.
Yeah, absolutely. And, it's, I guess in a way, I don't think it was intentional, but just rather coincidental timing that we have the OECD, issuing this very significant declaration and set of OECD principles on government access to personal data held by private entities, really just a day after the adequacy, the draft adequacy decision was issued. I mean, just to maybe provide a little bit of background on what that is and why it's significant. Really, I think it's been about 2 years or so that the OECD has been working on this issue and had launched this issue, this effort, I should say. Excuse me. It's the set of issues that are at play here in the transatlantic context and in the Schrems 2 cases, thinking about concerns around data flows, cross-border data flows specifically, the issues surrounding government access, the role that companies play, and of course, the necessity of providing privacy protections, right? So these three different issues: data flows, government access, privacy. I mean, these are issues globally, and they're issues globally for companies, not just in the transatlantic context. And I think what was recognized a few years ago, really starting with Japan's G20 leadership in 2019, was the need for something that then was called data-free flows with trust. And then I think flowing from that, a couple of years ago, the OECD launched this effort to really set out high-level principles regarding trusted government access to personal data held by the private sector, really looking to identify the commonalities amongst all of the OECD member companies. And I think it's very notable that the principles here that have been agreed to deal with some of the very same things that we've been talking about this entire time, right? Legitimate aims of government access collection, and then being necessary and proportionate, transparency, the importance of independent oversight, and of course, effective redress. And that's not all of them, but I'm just highlighting a few here. And so it's really quite notable, and I think quite striking here that we've got now a set of principles coming out the day after the adequacy decision, amongst 38 like-minded democracies, that really set out the rules of the game, or what some maybe even would say is a standard of sorts that suggests what the US is doing, and what the European member states are doing, and what Japan is doing, and what the UK is doing, and what other OECD members is doing, along these lines of redress, necessity, proportionality, etc., is all very much aligned, and it's really going to hopefully be helpful ultimately for regulators who are looking for standards around cross-border data transfers and these issues that we're talking about here. And I mean, it's important to note that this is not a binding document, right? It's what's known more as soft law, but it doesn't mean it doesn't make it any less significant or impactful. I mean, so we're really, certainly speaking from the ITI standpoint, we're really hopeful that the OECD principles get a lot of attention going forward, and indeed are impactful in not only positively impacting the discussion in the transatlantic context, but really making this whole area more of a global discussion about what is similar and common with the US and the EU member states and everyone else, as opposed to focusing on what overall now I think the OECD principles demonstrate are relatively minor differences.
And I mean, as let's outline again, the significance of this is that it's the first intergovernmental agreement on common approaches to privacy. So this is no small feat. Is there, I don't know if you know this, John, is there any follow-up to this in the OECD? I mean, will this be the conclusion of this work stream, or they will continue, go deeper? What is the expectation here?
I mean, that's I mean, it's a good question. I mean, there are lots of different, types of OECD instruments. I mean, the declaration, I think we should consider it, in and of itself, a whole document, if you will, a finished document. But if we look back, just historically, I mean, the OECD, whatever it was, I don't know, 40 years ago or however long ago it was, put out a very significant set of OECD privacy principles that have had very enduring and lasting impact. But one of the things that the OECD does, I mean, is they can always initiate a new effort if there was a need down the line to update the principles that are the subject of this declaration or something like that. But I think what's going to be most important with moving the OECD principles forward is what all of us do with them to kind of promote them, and to hopefully they really gain traction, for instance, with data protection authorities or other governments. And I mean, even some non-OECD members, particularly I think democratic societies, will probably recognize these principles in their practices as well. Yeah, I mean, the declaration is now published. It's been agreed to at the OECD ministerial this week. But its impact hopefully is just beginning.
Thank you for that overview, Joe. So I think we've reached the end of this conversation. Thanks again, John, for sharing your perspectives on the draft adequacy decision and the broader context of the recent US developments, as well as the OECD. I see that there are no further questions in the chat. I mean, this will certainly not be the last time that as ITI we conduct one of these conversations. I also mentioned our upcoming event. So we continue to be engaged. Please do not hesitate to reach out to us should you wish to discuss any of these topics any further. Thanks again for being with us today and for your attention, and looking forward to talking again. Have a good afternoon or good morning.